Thank you very much, and welcome to all of you to our event, Trailblazers in Diversity. This is another event in a week of activities that have been going on. I want to thank APALSA and also Law Career Services for putting together this particular event. I'm really excited to hear from our three Trailblazers. Really excited to hear their differing insights about their own experience in talking about diversity, about their lives, and about how they have become the successful lawyers and judge that they are. Talking about diversity is always a little bit looking past and looking forward, and this opportunity is with three people who have both a past in being champions of diversity and a future as well. And it's a great opportunity for you to think about your own legal career and how these issues play into those and how they will model the lawyer that you want to be. So thank you to all of you for coming here today. We have three panelists. What we're going to do is I'm going to first, while I'm at the podium, I will introduce the three of them. I have a biography. I apologize. I'm going to read much of their biographies. They're too long for me to remember all of, but they're too impressive for me to skip too many parts. So I want to share those with you in their entirety. Then we have some questions both about their personal experiences and their experiences lawyers, their interaction in kind of legal institutions, whether that's law firms, law school, or whatever that we'll ask. And if we have time, then we'll also see if there are questions from the audience. Three people I could ask 50 questions to if I had the time, so I have a few questions tucked into my back pocket as well. If we have time for that, I'll give you a chance as well. So let me introduce our three visitors. First, I want to introduce Honorable Victoria Kolakowski. Her Honor became the first transgender person ever to be elected as a trial judge in the United States when she was elected to an open seat in Alameda County in 2010. Judge Kolakowski has served for over a year in a criminal department hearing misdemeanor trials and felony preliminary hearings. Prior to her election, she had 21 years of experience as an administrative law judge and attorney. As an ALJ, she served at both the California Department of Insurance and the California Public Utilities Commission. As a lawyer, or as an attorney, she worked as a sole practitioner, she worked in a law firm, and as general counsel for a publicly traded company as well. She was also a senior government attorney, having argued before federal courts and recovered billions of dollars for consumers that have been lost during the California energy crisis. She was a founding officer of Equality California, the state's largest LGBT advocacy group, and was a co-chair of the board of the Transgender Law Center, a local legal organization, actually proud to say founded by a friend of mine, of which I'm a founding donor. It's a great organization. Second, I will introduce Raymond Marshall. Raymond Marshall is a partner at Bingham McCutcheon, another wildly successful local law firm, where he represents clients in both complex civil and criminal litigation. He's conducted internal investigations in cases alleging insider trading, securities fraud, accounting irregularities, antitrust violations, and other corporate wrongdoing.
Alleged.
Yes, alleged corporate wrongdoing. No one's happy when they see you coming towards them and their corporations, are they? Mr. Marshall has represented corporate and individual clients in civil, criminal, and administrative proceedings brought by governmental authorities, including the DOJ and the offices of various U.S. attorneys, state attorneys general, and DAs. He's lectured extensively on white-collar crime and business regulation and environmental enforcement issues. In March 2009, Mr. Marshall argued on behalf of 5 of the leading civil rights groups in the country, the Asian Pacific American Legal Center, California State Conference of the NAACP, Equal Justice Society, the Mexican American Legal Defense and Education Fund, and the NAACP Legal Defense and Education Fund before the California Supreme Court. Some of you may have seen that on television. Arguing that allowing Proposition 8 to stand could be detrimental to other minority groups who could easily become targets of initiative campaigns seeking to take away their rights. The third person I want to introduce at my far left is Kevin Fong, a partner at Pillsbury. Mr. Fong is currently the leader of Pillsbury's appellate practice, which is ranked by U.S. News as a national Tier 1 appellate practice. He recently served as leader of the firm's 40-lawyer litigation team in San Francisco. Mr. Fong is identified as the leading California appellate lawyer by Chambers USA in its 2011 rankings. He's appeared in 85 published decisions, all as lawyers, never as a defendant, including arguments in 6 cases before the California Supreme Court, prevailing in 5 of the 6 cases. Mr. Fong's arguments have helped shape the law in numerous fields, establishing important precedents in the fields of environmental law and banking, as 2 examples. He's authored briefs in leading cases before numerous circuit courts and the U.S. Supreme Court, including a landmark administrative law case. Mr. Fong was elected to the California Academy of Appellate Lawyers in 1991 and served in 2010-11 as its president. Mr. Fong has been a leader in promoting diversity in the legal profession for more than 25 years and chaired his firm's diversity committee for more than a decade. Mr. Fong was an honoree at the 2006 annual dinner of the Asian Law Caucus, another esteemed organization that this law school has many contacts with, I'm happy to say. The Asian Law Caucus honored him for his leadership in promoting diversity. In 2008, he received a Trailblazer Award from the National Asian Pacific American Bar Association at its 20th annual convention. This is a group of 3 tremendous people. I just want to welcome them and thank them for coming. If I may, I'm now going to take a seat. I'm hoping that by not looming over our 3 guests, it will allow them to feel that they can speak to whatever length they wish about these questions, or at least until I ask them to wrap it up if that becomes necessary, which I really will only do with Judge Kolakowski, because you never get to do that with the judge. They get to do it to you.
I thought you said go on and on.
No, not at all.
My wife says.
I have no basis to say that, I assure you. So let me begin. The first few questions I have are, these are questions I think that you knew a little bit about. They're a little bit about your experience, your past experience. So the first question is for you, Your Honor. Can you tell us a little bit about your struggle to become a lawyer, specifically with the Louisiana State Bar Association, and where you found the resources to deal with that challenge?
Okay. What happened to me when I transitioned and went from being male publicly to female in my last semester in law school, which was really a very, very uncomfortable thing to do. I handled it not as well as I could have, and the school made sure they handled it even worse. And so it was a very awkward situation. And then I graduated and I applied to take the bar exam in Louisiana. I'd gone to Louisiana State University in Baton Rouge. And I'm not originally from Louisiana, but it's a long story how I got there, and we're not going to go there. But when I applied to take the bar exam, the Louisiana State Bar Association received my application and rejected it because they said I was not of sound mind because of being transgender. And so I had to appeal that to the state Supreme Court. And I did that myself. I wrote my own brief, did the whole thing, put the whole thing together while I was studying for the bar exam, and filed this. And it was really actually kind of amazing because I filed it on Monday midday, and then Wednesday morning I got a phone call from the court saying appeal was granted. The decision, actually, I've discovered you can look at it on Lexis. It's apparently now online, and so I mean it's something very short like appeal granted or something. And so it's a very, very substantive decision, right? And I hadn't even known what was going on until later. How I heard a little bit about the story about what happened with that, because my ex was out one day protesting. That's the way she is. It was her morning protest, and the local district attorney was trying to find a case to overturn Roe v. Wade, and so everybody protested in front of the DA's office every morning, all the women attorneys. And so she was walking along protesting, and she heard this woman in front of her saying, blah, 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 bar exam, blah, 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 transsexual. And she said, pardon me, I'm just curious what you're talking about. And it turns out this was a law clerk for one of the state Supreme Court justices in Louisiana. And she said that she had gotten my application, she'd looked at it, and she went to her justice and said, did you see this poor woman doesn't even know she can take the bar exam? And so he said, yeah, I know, let's get the boys together, that being the Supreme Court. And they grabbed them all, got into a conference room, and 10 minutes later they voted, yeah, and that was the decision. And so now Louisiana has moved forward. There is actually a woman on the Supreme Court there. Actually, she was Chief Justice. But when I was applying for jobs, I would, my law school said that I should come out in my cover letters to people, and I should just say that I was transsexual so that I wouldn't mislead people into thinking that I was a real woman. And so I had this really weird experience. I had my whole background. The law firms where I clerked in my summer asked me not to tell anybody I worked for them. I mean, they asked me to remove them from the resume. And which was kind of a very awkward thing to do because it's sort of like erasing my entire past. But I would apply for jobs, I would go and interview, I would have very good interviews, and then I wouldn't hear anything. And I'd call back like 2 or 3 weeks later, and they would say, the hiring partner would say, I've been sitting here trying to figure out how to write the letter. You know, we just don't think you'd be a good fit here. Which was basically code word for, you know, you don't belong. And in general, somebody that they would talk to about from my past was telling people. And I knew that happened because when I finally did get an offer from someplace that didn't call any of my references, or anybody, they just hired me on the spot. I was so impressed. One of the attorneys there got a phone call from an attorney at one of the firms where I had interviewed to warn him about me, which is how I got outed to my entire new firm. But one of the things that was very difficult about that experience was that I would go in and interview places, and I knew what was going on. I even had, in one case, a headhunter. I went to the headhunter, and she called me. Actually, she came to me and said, I have this firm. They would really be great. They would love you. I placed I was the patent attorney, the entire patent group there. I said, they're not going to hire me. I can tell you that because I've talked to them before, and I know this is an issue for them. And she said, oh, no, you're wrong. I'll talk to the head of the group. And so she called me back 2 or 3 days later, and she said, oh, my God, Vicki, you're right. I called and said that one of the partners would quit if they hired you. And it's like, and I thought, how sad that somebody would actually think of quitting and taking their business elsewhere because of me. I mean, I didn't think I had that much power. But one of the things that I discovered was a lot of times, and this is one of the things that we have to overcome sometimes, is that people project in law firms. Lawyers can be very, very nervous, scared people. They're worried about losing their business or worried about clients going away. And they project their fears and their own prejudices sometimes onto the firm, the clients, to everybody around them. And so that can be a bit of a challenge. Because it's like, they don't have a problem with you. But what will the clients think? Well, odds are the clients actually won't care at all. And that's one of the reasons why the folks who've worked on, and a number of us have worked on diversity issues over the years, have found that getting the clients to say that they like having people like diversity helps, because then they don't have that fear. They don't have that concern. As a matter of fact, it can be a positive thing sometimes. So if you can sell the clients on it, big corporate clients, things like that, in-house counsel, then that's a really big deal. Now, how I personally got through a lot of this was, I have to be honest, it was family and friends. I couldn't have done this alone. I couldn't have made it to where I am right now without the support of a family that I knew would be there for me, that would have my back, and friends, many of whom I drove crazy over the years so much so that I burned some friends out just for the stress of all this. But really, building a support network for yourself of people, family, friends, if you have a loving, supportive spouse, that is wonderful. You need to cherish those things, and because those would be the support. Because honestly, when you go to sleep at night, you wake up in the morning, your law partners are not going to be in bed with you. They're not going to be the ones who are there with you when you're crying, when everything's going wrong. they're not the ones who you can always count on to have your back. And I don't mean that to be disparaging of your colleagues, but the thing is you have to find out as you go through life, who are the people who are with you, who understand you, who like you, who love you, and be with them. Now, one of the things that was hard, though, I wanted to say very quickly, is that when I would interview with these places, people would say to me, and I would get turned down and say, well, you wouldn't want to work with people like that anyway. You don't want to work with people who don't want to work with you. And I thought, yeah, but I want to work somewhere. You know, and this isn't a problem, which we'll probably get to talk a little bit more. You know, when times are hard, when you're looking for a job, you know, it can be very, very scary. And you sort of want to have something, anything that you can hold on to. But I think that there are ways that you can get past that, and we'll talk more about that later. But so that's my answer to the first question is really the people around and are supportive are going to be making all the difference in the world. There are colleagues who are friends who will have your back. Find out who those people are, and cherish them.
From what the judges said, I want to ask our other two panelists. This experience of being told it's just not a fit. It's an experience that many people from minority communities have experienced. The kind of innocuous justification or description of why you don't look at or seem like me, the hiring partner, or me, the person who hires at the nonprofit organization, or me, the person who's hiring the lawyer, whoever that person is. What have you done with that challenge in your own past? Either.
Well, I mean, the fit question issue is one which is still there but changed. Because I'll be honest, our firm's hiring criteria has been the same since I came out of law school, and how it's applied has changed over a period of time, perhaps. But I've been chair of our hiring committee, and our three criteria that we ask ourselves when we interview law students are can do, which means can they do the work? And we usually look at grades and other academic achievements. We ask, will do. Will they do the work? Do they have a work ethic? Are they going to have the stamina and put in the time that a practice like ours demands? And then we do ask fit. What we ask to fit is, are these people that we want to work with? Are they folks that you want to socialize with? Are these folks that you want to put in front of clients and hopefully grow with as a firm? And so those three criteria are ones which existed when I came out of law school and which we use today. Now, I would say a major difference, when I came out of law school, and it's a long time, it was in '78, the fit question, whether you were talking to San Francisco, New York, Philadelphia, Detroit, if you wanted to work in a major law firm, and Kevin could attest to this, and I was coming from Harvard, it didn't really matter what city you worked in. If you were a black law student and you wanted to work in a major, we didn't have such thing as an AmLaw, but a major national law firm, or major law firm in any city, you were going to be maybe the singular of one or two black attorneys in the firm, period. And so it almost begs the question of whether, quote, you fit in, because no matter where you went, if you wanted to work in that profile, then you were going to be one of one, or one of two, maybe one of three. And there weren't black partners around. Those were rare creatures. There weren't black lawyers showing up on campus to interview. And I can specifically recall being asked the question in my interview, my second year for a summer associate position, how will you feel being the only black attorney? And I appreciated, frankly, lawyers who asked that question. Because it was an easy response was, well, I knew I wanted to work in a major law firm in an urban city and do sophisticated litigation. That was what I wanted to do. And so my response was, if I wanted to do that, I was going to be the only one anyway. So that's what I wanted to do, so I would fit in well. And so I appreciated that. But I recall, even at the firm I'm at now, I had a partner when I was a summer associate who came in to talk to me my first few days there. to say, you know, you're the only black person we have here. There were three associates that year, and who was very nice, but wanted to say, you know, if you have any issues, you know, it was maybe awkward for you because you're the only person. Now they kept confusing me with the other person over there that summer, but I appreciated it. So in terms of the fit is important. In terms of the culture, we'll get into that because I think every firm has a different culture, every city has a different culture. So fit's an appropriate question. It's only when it's used in a prejudicial way to prevent you from otherwise having the opportunity that you've earned.
The definition of fit probably has evolved over time. It's no longer firms looking for people like us, but it's still looking for people we like.
So let me...
Pretty hard to hire people you don't like.
Yes, I hope that's the case. So let me follow up and ask you the question, Mr. Fong, about law school. One of the things that I had read about here was that you were one of 4 Asian American students in your entering class at Harvard of a class of 550. Can you tell us about that experience?
Not only that, there were 4 1L sections in my class at Harvard, so we were evenly distributed. This was also during the era of affirmative action, so occasionally I get asked, was there affirmative action at Harvard, especially for Asians? And after thinking about it, Harvard, in a way, may have been ahead of its time because it probably had the first stealth affirmative action program, in the sense that they said it was there, but you just couldn't see it. One advantage of having a relatively small number of Asian Americans in the law school class is that there was no question as to whether you were in and active in the Asian American Law Students Association, because by definition it was a very cohesive group. We sort of bonded instantly, and it was a very different situation from now, where you have a very large number of Asian American law students. It's sort of an opt-in, opt-out situation. Some students are very active, some people take a leadership position, some participate in the sense of showing up occasionally, and others just opt not to be active. There was something a little bit nice about having a group that was, your group. One aspect of that is that there's nowhere to hide. If you say something really stupid in your first year torts class, you can't say, oh, it was the other Asian guy, not me. They knew it was you because you were it. So it was your opportunity to shine or not.
And then, Mr. Marshall, you had a similar experience, I assume, in that you were also at Harvard Law School, and before that had been in college in Idaho. How was that for you? And then let me also ask, how has that shaped anything about your later legal experience? What you later did in the law?
Well, the Idaho experience was very different, obviously, than the Harvard experience. And the Reader's Digest version, I ended up in Idaho more by accident than by design. My father was in the military, and so I ended up there through weird circumstances. But there were 2 different experiences. In Idaho as an undergrad, we had a limited number. It was a private school outside of Boise, Presbyterian affiliated. We had probably maybe 18 black students at any one time at the college, a small school, but they're all jocks. We were all there as jocks. Either you were playing baseball, football, or basketball. We had one black female who was there as the girlfriend of someone who's playing baseball. And that was it in terms of your cultural diversity. There weren't Asian, there weren't Hispanic at the school. And so it wasn't until I went to Harvard that, for me, that it was a completely different world in terms of, for the first time, being surrounded with the most brilliant minority students who were also jocks and beautiful that I'd ever experienced. It was great, because all of a sudden you weren't just being singled out as, well, he's different, or he's exceptional, he's okay because he's different from the rest, as people would point out during my high school and college days. Now all of a sudden you were in law school, and they were just talented people left and right, and who were great athletes as undergrads. They were all conference in the Pac-10, and yet they were pulling down 3.9s and having huge LSAT scores. That was the profile of what you were all of a sudden experiencing. And for me, that was a real kick, and it was just great. And I was there at the same time that Kevin was, although a few years ahead. We had 10% of our student body was black there. And APALSA was very strong at the time. It was very strong. And we came to Harvard, our class, in '75. You might recall '75 was Baki in that era. And so the first challenge, and also in Boston, you had busing was in the highlight at the time. And there were riots in Boston, major riots in Boston that were receiving national attention. So we arrived on a campus at a school that was in disarray from our standpoint, made to feel very unwanted by the larger student body, as if you were only there for affirmative action. And so our classroom experience was we had been in study groups that were all black. And that was fine, because these were very talented people. And for me, and I think I've said this to other students, is find out what it is that you want to do in law school and take advantage of that experience. And for me, from where I was coming from, I worked hard academically, very hard. I was sort of a nerd there, but also did a lot of things outside. And because I was there at a time where busing was an issue, where the Federalist Society on campus was coming into their own, where students on the right were becoming more empowered, I was doing a lot of stuff in Boston and in Cambridge at the time, outside the school. Because that's what I wanted to do, take advantage for me of what I saw as a unique opportunity. So for me, my 3 years there, I had a lot of fun, it was great, but it was two different experiences in terms of Idaho versus Harvard. And when I came out and said, how does it relate to my practice? For me, I knew I wanted to work in a large city, probably on the West Coast, a firm that had a reputation, that had some cachet, and if I didn't like it, well, it would make me mobile after 2 or 3 years. That was sort of it. So I moved around a lot. I had no really home because I was a military family. Interviewed a lot of different places. Settled on the firm I'm at now. Been there 33 years. But I always felt that it was important for me. I don't ask other people to do this, but for me, with my background experience, that being presented with the opportunity to be at a place like McCutcheon is being now, to have a seat at the table where decisions are being made, to use that. Because I always felt like I knew people, including my parents and friends and colleagues, who came from the segregated South, who were very bright and never had opportunities because of racism and injustice. And I always felt if I had the opportunity to be at a table, I would not be shy about speaking my mind. I would not be shy about speaking out on issues. And I figured at that time, the worst that could be happening is McCutcheon get fired and I go work for Mofo fired and I go work for Pillsbury. And so that was just my sort of mindset. And I've always felt that way in my professional career, using the firm where I work at as a platform to do things that I want to do outside the firm. But that's me. I mean, I very much love my practice, but it is a platform and a base to do other things that are important to me while still making money.
as minority lawyers, or as minority law students, what's our relationship to groups like APALSA, groups like APALSA, professional legal groups like bailiff, or other bar groups? Do we have an obligation to them? Should we have expectations of these groups? How have the three of you, if anyone wants to come, how have you interacted with, let's say maybe just the professional side of it, not the law students? How have you interacted with other groups that represent your community? Anyone?
Go
Go
ahead.
ahead, yeah, go for it.
Oh, goodness gracious.
We defer to the judge.
I mean, well, it's sort of, with regard to law school, we had nothing, because when I was in Louisiana, my ex was the first person to come out at LSU Law School. And she came out, and it was really actually interesting. I was invited, I spoke last fall at LSU, at my own law school. I was invited by Outlaw, the gay law student group there, which is only 2 years old. And so I was their first speaker that they brought in. And so, which was very exciting. But we didn't have anything like that. But then I moved out here, we had bailiff, and I've been involved with bailiff. I've been on bailiff's board. I got involved with I was co-chair of the committee, well, at that time it was called the Committee on Gay and Lesbian Issues of the Bar Association of San Francisco. And I had gotten involved very early on in a number of professional groups. I think it is important to do that, but also I was trying to, when I started out, I was really focusing on trying to change the world, make it better, and I think those are really useful things, but I think that it would have helped me a lot, by the way, if I had spent more time my first 2 or 3 years focusing on increasing my billable hours and less on, trying to, I co-authored Berkeley's Domestic Partner Registry Ordinance my first year out here, but I didn't make my billings for the year, and so eventually I wound up getting laid. No, sorry, we didn't do layoffs back then. I was terminated for cause for lack of billable hours that the firm wasn't bringing in. I wasn't either, and so, but it was something that I didn't focus on the way that I could have. But and so I think those things are really valuable to be resources, but I think that they're also even more valuable once you've got yourself firmly established and ensconced in your practice.
So this is the very beginning of the year of the dragon, I believe.
Mm-hmm.
So because of that, I remember that almost exactly 24 years ago, I was sworn in as president of the Asian American Bar Association. I remember because it was also the year of the dragon. And it wasn't 12 years ago, so it had to have been 24 years ago.
That's not possible.
And a little while back, I dug through some of my old files, and I actually had my inauguration speech as the president. And in that speech, I was sort of projecting out my vision for the future, that someday you would have an Asian American justice on the California Supreme Court. Then there were none. Now there are 4 out of 7, a majority. I also speculated that someday you would have an Asian American district attorney. With that, I actually wasn't that far off by a few years, because Kamala Harris became district attorney and now is attorney general. And I also went down the list, that you might have an Asian American public defender. We have one, Jeff Adachi. You might even have an Asian American mayor. We've got 2, Ed Lee and Mayor Kwan in Oakland. In fact, I was telling people during election season, I was probably one of the very few Asian American attorneys who wasn't running for mayor of San Francisco. Everybody was. Jeff was running for mayor, David Chu was running for mayor, Ed was running for mayor, Phil Ting, who isn't a lawyer but was executive director of the caucus, he was running for mayor. So things change, and I'd like to think that ABA and all of the other diversity bar associations had a hand in that. If not directly, then at least indirectly, because all of these organizations are in fact, farm teams where you can hone your leadership skills with relatively low risk, low stakes. But if you like being a leader in one of the diversity bar associations, then you might try your hand at being a leader of the Bar Association of San Francisco, or the State Bar of California, or the American Bar Association. For young lawyers coming up through the ranks, in most institutional settings, in a government attorney's office, or in a law firm, or in a law school, there are very few opportunities in your first few years of practice to hone your leadership skills, because you don't look like you're going to be the likely leader if you're just starting out. But through the diversity bar associations, you can practice the skills that you are going to need sooner or later down the line. And better to try it and make your mistakes among friends where nobody gets hurt than where it really matters and your career depends upon it.
Sort of a mixture of both what Kevin and the judge have said. I have, over the years, been more active in majority bar and majority organizations than minority bar associations. I mean, I'm a member of Charles Houston National Bar Association, which are the two local and national black bar attorney associations. But I think both groups and minority bar associations are of great value for a lot of reasons. But when I came out of law school and came to San Francisco, frankly, I was still having the experience as a young associate of trying to too often validate why I was working in a large law firm instead of working in government or working in Oakland or doing something else. And so while the associations were supportive, at another level, they were geared more towards, at least for us, for black attorneys, if you practice in Oakland, as opposed to practicing downtown San Francisco. And that was not my professional life. And so I needed to find something else in addition to, not to substitute for, but in addition to, that was more akin to what I was actually doing day-to-day professionally and the kind of practice that I had. And so I actually, and with Kevin too, I think we've all been, I just say, we've all been very supportive of our minority bar associations. And we'll get into the cross-pollination of our respective groups, whether it's NAPABA working with one group, and LaRaza working with one group, or Bailiff. I mean, we all support each other. But my experience outside was to work with the Bar Association of San Francisco, the State Bar of California, the American Bar Association, especially groups within the bar, the Commission on Women within the ABA, the Commission on Equality within the ABA, the Metro Bar Association, which is the large urban center bars, because that was one that was appealing to me, it was fun, and it was similar to my large firm practice.
One of the things that actually all four of us, I was going to say the three of you, but I think all four of us have had a connection with is Prop 8. Mr. Marshall and I actually moderated a different panel that he was on a couple of years ago in the midst of a lot of the litigation. I know Mr. Fong also signed on the League of Women Voters brief that went forward, and you were on Equality California at that time, I believe, or right after.
Oddly enough, I was one of the signatory ministers on the People of Faith, and so.
Fantastic, and I was on the law professor's brief that Donna Ryu, now Magistrate Judge Donna Ryu, put forward. So that was there were many, although there were many different minority bar groups, minority groups, and other kind of smaller legal groups that kind of came forward when the Prop 8 litigation started. This maybe goes to your point about cross-pollination, or at least about the concerns that are shared among groups of this kind. what was either what is the concern that multiple minority groups shared around Prop 8, or what is the risk that is presented by initiatives of that type?
Well, for me it was real easy, which is a very basic concept that we weren't able to convince the majority of the court to share, but it has the idea that, you know, the Constitution says that all people are supposed to be treated equal. Very simple concept. It didn't say that all white people would be treated equal, all straight people would be treated equal, all white Protestants would be treated equal. It said all people. And so that's what essentially we tried to put forth and argue, that it didn't really matter whether it was race you were talking about, it didn't matter whether it was gender, it didn't matter whether it was religion, and it didn't matter whether it was orientation. And the concept was, that I think shared by all of us who believe in equal rights and fairness, was that if you can discriminate against one person or one group, then you can discriminate against all people in all groups, including me. It was really that simple. And so we felt that it was important to stand up and say that in a very public way, because one group being discriminated against, it doesn't take much than to discriminate against the next group. And that was important. And I felt it was really important in California and in San Francisco, because we had actually a history, just by way of background, but Kevin might recall this. I think it might have been the year, either I was president of the Bar Association of the year before, where there were divisions between the gay community and the black community with regards to over the issue of religion, and you had people like Reverend James Brown, and well-respected ministers in the black community who were against gay rights, frankly, and it created a fissure within the Bar Association. And then you start having issues between, well, who's more discriminated against the most? Are Asians separate because their profile as the golden minority? What about black and Latinos? What about women? Well, what about Jews? And we had that issue within the bar. We had to have Felton Henderson, judge, come and speak to all the groups to tone down, to say that we're all in it together. And you know, Kevin can speak to it. Even when we set goals and timetables, we had a discussion about, do you have separate goals and timetables for separate ethnic groups, and all those issues. And so I personally felt that it was important that we coalesce together publicly in a very strong way and say that, you know, we support each other, and discrimination against one is discrimination against all.
The best brief I ever wrote, bar none, was the amicus brief I wrote in 2007 in the predecessor case, in re marriage cases before the California Supreme Court. Some of my friends in the public interest sector had this great idea saying, gee, why don't we get together all the Asian American groups, both legal, community groups, etc., and have them write an amicus brief in favor of the same-sex marriage side of the in-re marriage cases. And when you think about it, to almost state that as an impossibility. I mean, how are you going to get all these Asian American groups that have very diverse interests, have very diverse memberships, and most of whom don't have any views one way or the other on same-sex marriage? How are you going to get them all to sign on to an amicus brief on what is a somewhat divisive issue? So we proceeded ahead, and at the end of the day, we got 63 Asian American organizations to sign on to this brief. The basic message of the brief was that marriage is a fundamental interest under California law, and it's a fundamental interest not just because of the importance of marriage to individuals, but because of the importance of marriage to society as a whole in integrating individuals into society through the institution of marriage. And with the help of some really brilliant scholars in Asian American studies, we traced through the history of 3 or 4 Asian groups: Chinese Americans, Filipino Americans, Japanese Americans, and even Punjabi Mexican Americans, and show for each of the groups in a very different way marriage was essential in either helping those groups integrate into society or serving as an obstacle to integrating those groups into society for those groups for whom marriage was not available. It was really an eye-opening experience writing the brief. Sometimes you write an appellate brief that has a catchy legal issue, some new legal theory. And we did have this spin on the legal issues that was a little bit different than the party, showing that marriage was a fundamental interest as opposed to the sort of group type analysis that some of the other parties were taking. Sometimes you have a brief that gives a historical context, sort of showing how it fits into the history of California or the US. And sometimes you have a brief which tells the personal stories of people who are affected by the legal issues. Well, I had this brief that had all 3 of them thrown in together. It was quite a treat to write the brief. It was a really, really talented team of public interest lawyers that we were working with. I have no idea if it made a difference at all in the decision of the court in 2008. But I can tell you, it did make a difference in terms of community organizing, because suddenly you had a narrative, you had a story to tell to Asian American communities as to why they should care about this issue, which had never really been articulated before. It was always, oh, here's why you should care about somebody else's issue. And we were able to tell the story of why you should care because it's your own issue.
When it comes to litigation of this nature, I really cannot make any comments. So I can talk about some other things about diversity, about coming together groups, but maybe a different comment.
Okay, absolutely. Any questions from the audience?
Please.
I've monopolized the time a little bit too much. If you don't have any, I have one for you. Please, at the back.
I have one question. It's directed to Mr. Fong. The brief you were just talking about, I believe you kind of analogized gay marriages with the discrimination based on Chinese marriages in the past. So I was wondering, have you used, that type of writing in previous briefs before to kind of link diversity in one area to another to try to analogize and direct the point?
I've always been looking for opportunities to do so, but they don't come up that often when you're representing multinational energy companies, and telecommunication companies, and financial institutions. Sometimes issues of diversity come up, not so much in the brief writing, but in the interaction with your own clients. So once I did a mediation before the Ninth Circuit where my client was a real estate developer from Japan. He had a problem with an apartment complex project in the Philippines, or no, in Guam. The other side was a contractor based in the Philippines. The mediator was from San Francisco, from the Ninth Circuit staff. We did the mediation in Hawaii, and it was like being in the United Nations because my client spoke only Japanese, and he had his own personal interpreter. The other side spoke only Tagalog, and he had his interpreter. The mediator and I were there just sort of watching this all transpire, but because my wife grew up in Taiwan, and when she's with her siblings, they speak only Mandarin. They just sort of ignore me. I'm there in the sideline. You get very, very good at watching and listening, and even if you don't understand a word, you can really figure out what's going on. And if you apply those same skills in a mediation context, probably gave me an edge over the other attorney who just had not a clue what was happening. It gets even better because not only is Mandarin the language of choice in my wife's family, but as my son was growing up, until he started kindergarten and 5 years old, the only language spoken at the dining room table between him and my wife would be Mandarin. We always thought I would pick up Mandarin along the way. Never happened. I just have an awful ear for languages. But you can sort of tell when they're talking about you. When they point and laugh, you know they're talking about you. Similarly, I got hired about a year ago to represent an Indian tribe in the Northwest in a major property tax dispute of a local county. And one of the things the tribe was looking for is somebody who would have at least a little bit of empathy and understanding for what it was like to be an Indian tribe in the United States. And I'm sure they would have preferred to have a Native American appellate attorney, but there aren't that many Native American attorneys in any specialty in the United States. And I think it probably helped a bit, you know, that I had at least some background in dealing with diverse cultures. In addition, my wife and I just had an interest in Native American culture. We spend, for at least the last 6 years, we spend every Christmas day at Taos Pueblo in New Mexico. You know, we just took a 2-week vacation last fall through the Navajo Nation in Arizona. And things like that make a client feel a little bit more comfortable than having somebody who comes from what really is a culture that would be foreign to what their members are used to.
Another question?
This is for anybody on the panel. Do you see in the future, I guess, a more progressive, more open door for diverse law students like us to be at those high places, to be a judge, to be in a big firm? Or do you think it's not growing as fast as it should be? The opportunity isn't as open as it should be?
Both, which is to say that, which is to say I think opportunities are great coming out of law school now if you're a student to do anything and everything that you want, from public interest to private practice to in-house to teaching to large multinational law firms. I think you can do all of that. The opportunities are there. So it's a very different day. I'm very encouraged in terms of the opportunities that present themselves to you. And notwithstanding the state of the economy, because I also think the economy is picking up and we're hiring more these days for the next couple of years. Having said that, your question is, are we where we should be or want to be? My personal answer is no. I haven't talked to Kevin in a while. But I think that going back to what days when we were setting the goals and timetables, and we were talking about what the future would be in terms of, at least in the law firms and corporations, I was more optimistic. There was a larger pool, perhaps, students coming out of the California feeder schools into firms. But I look at the numbers now. As I said, I've been practicing 30 plus years, and there's still 2% black partners in the major law firms. It was about 1.5 when I came out of law school, 1%. So they moved from 1 to 2 in 30 years. That's not very good. Latino is probably the same. Asian, probably, numbers have not moved. But for entry level, coming up the ranks, opportunities, business development, yeah, I think you can do anything and everything. I'm very optimistic and bullish in that.
For Asian Americans, I actually think it's about time that we revisit, update, and maybe reset our own stereotypes. I was at the National Asian Pacific American Bar Association annual convention in Atlanta, of all places, last year. And I was on a panel where we were discussing some very interesting survey results. The Napaba Foundation got some money and did a survey of several hundred partners and associates in law firms, both Asian and non-Asian. And one of the very interesting results was that when you asked people about their perceptions of Asian American associates, especially on issues of relationships and sociability and sort of soft skills, soft people skills, the Asian American partners and associates both perceived that Asian American associates were doing less well than their white peers in building relationships, being sociable, and building their soft interpersonal skills, whereas the white attorneys thought that the Asian American associates were doing just fine. Now, of course, there are a lot of different possible interpretations. Now, perhaps, the white attorneys were just too polite to say that the Asian American attorneys, were no good at interpersonal stuff. But if you put aside that possibility, it could be that our own perceptions of ourselves are really fixed 30, 20, or 10 years ago, that they're lagging the reality, and that people your age actually do pretty well in terms of relationship building with your non-Asian peers, in part because of social networks and the fact that people have generally tended to grow up in more integrated settings in K through 12, in college, and law school. And that the baggage you have is just the perceptions that everybody has built up over the last 30 years, saying, when I was in law school, and that sort of hangs on, and you don't quite know which is true, what you perceive as the reality or what people tell you is the reality. Why does that make a difference? Okay, here's something for those of you in the academic field to explore. There is this field of psychology, I guess social psychology, that focuses on stereotype threat. Stereotype threat is a theory developed by Claude Steele probably about 10, 15 years ago, that says that in certain settings, let's say taking the SAT or a job interview or playing baseball, if you perceive yourself to be in a group that doesn't do well at that task, you will not do well at that task. If you perceive that because you're a woman, you're not supposed to do well on the math portion of the SAT, you will not do well on the math portion of the SAT. You will choke. Maybe the same thing happens in the social setting, that if you perceive that because you're Asian, you're not going to do as well in a cocktail party or schmoozing with a client or in a job interview or something that requires soft skills, interpersonal skills, sociability, relationship building, if that's your perception, that will become the reality. If that's true, then I think the Asian American attorneys and law students owe it to themselves to re-examine, okay, are we just is it just an echo chamber where we keep telling ourselves that we're not good at this and that's what's making us not good at this? That, along with whatever you see on the media or don't see in the media. If you don't see Asian American attorneys on TV, subconsciously you're going to think, wow, we're never going to be attorneys, we're never going to be judges, when in fact, if you go down to City Hall, there are plenty of Asian American judges in the Superior Court. But you don't perceive that because it's not part of the common media and the mythology of it all.
I mean, that's what we have.
to that.
Yeah, well, actually, to anything, but about the opportunities that this traces back to the original question about where are the opportunities. There's not a 30-year history of transgender people in law firms, but
no, but you know, there's something. There's a lot to what's being said, and also, you know, one of the things that I had to come to deal with with myself was that to realize that I could go through life bitter and angry that people were mistreating me, or I could just keep going and live my life. And you know, if you carry that baggage with, if you put yourself in that sort of, I guess, victim mentality, if you think I'm encountering all these problems, life's not fair, woe is me, blah, 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 you can get yourself really down and you can get yourself really trapped in that. And so for me, I had to come to a realization that, first of all, sometimes I was contributing to my own failures, and that didn't necessarily excuse other people for some of their own biases or prejudices, but you know, it wasn't just all that either. And so, and also, it's not very productive or helpful to just focus on the fact that everybody else isn't nice or life isn't fair. Because the truth is that nobody's ever promised that life would be fair. No one, coming to the realization that nobody guarantees me that I'm gonna have a job. You know, if you go through, you think there's this compact, this social compact that you've gone through, and you go to school and you come out, there's a job. There is no such thing. You create your future yourself by working hard at the stuff and by not giving up. And so, and I'm not trying to be Pollyannish about it, but you know, you know, all you have to do is just think positive thoughts, you can make it through. But if you just dwell upon the obstacles that you face, or the problems, or see the things that divide you, or the things that make it impossible, then you're never going to get anywhere. The truth is that it's not possible for me to be where I am, except that I am. And the reason I'm here doing this is because I realized that it was possible. I think that all of us are doing things that people didn't expect of us because we went ahead and did them. And we didn't stop to wait for somebody else to validate that, or to say that that's the right way to go about doing it, or to be the person that we want to be. And sometimes, you know, we run into our own stereotypes and issues. And I mean, and I think that Ray was talking about some of that earlier. That you know, you come out and you're an African American attorney. Why aren't you working in Oakland? Why aren't you doing this sort of thing? What do you mean complex civil litigation in downtown big firm stuff? I mean, you know, there were these expectations that people have of you and that you can put on yourself. The truth is that you need to figure out who you are and what you want to be and how you're going to move forward, and just focus on that.
When my son was growing up, he was really into swimming, and he would swim competitively in swim meets from age 6 on up to through high school. And one of the things that you watch swim coaches is they never tell the little kids, here's what can go wrong. They just tell them how to swim. Because if something goes wrong, and the classic thing is, you know, you get this little 6-year-old, they get up on the diving block, which is literally about 2 feet above the water, and they slip. So instead of diving out toward the other side of the pool, they sort of just go straight down like a rock. And you know, after about 10, 15 seconds, they surface. But without having ever been told by the coach, they know exactly what to do. You catch your breath, you look around, you put yourself in the right direction, and you start swimming. Now, if the coach had told them, gee, here's what might go wrong, and here's what you should think about doing when things go wrong, sure enough, things would go wrong. So I think a lot of times when, you know, law students are looking ahead toward the future, you focus too much on everything that can go wrong. And if you focus on it hard enough, you can actually make it happen. It will go wrong.
we have run out of time, and I don't know how much longer we have this room. So But this is not the end of the conversation. I hope that our three guests will join us in the reception, which is right next door, so we can have more conversation about it. Those of you who didn't want to ask a question in the big room can ask it there. I want to first thank APALSA and Law Career Services for putting this together. Tiffany, I know, was my primary contact. If there were other people, I thank you all, but thank you to Tiffany as well. Thank you to Suzanne and her folks at Career Services who just always do such an exceptionally good job trying to make that dream a reality, that there is a job just waiting out there. And then particularly, of course, I want to thank our guests. I want to thank Mr. Fong, Mr. Marshall, and Judge Kolakowski for sharing their insights. We have talked about law school, we've talked about early career, we've talked about late career, we've talked about society, and we've even had just some lessons in life and swim lessons. So all of that is great. I want to thank them for sharing all of that, and thank you all for coming. So thank you.